first case to come before the court for argument today is State of Ohio versus Nicholas Bland. Each party will have 15 minutes to present its arguments. If you want to retain reserve time for rebuttal, let me know before you get started. I'll do my best to try to track that for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up and remain behind the podium. Don't use names of any children in any case that might come up that would fit for or minors or victims. We have read your briefs and we are ready to proceed whenever you are. Rebuttal time?
Yes, 5 minutes.
Okay.
Good morning, Your Honor. Giovanna Bremke on behalf of Mr. Bland this morning. Mr. Bland was indicted on 5 separate indictments from January 2017 to July 2017. There was procedurally, I'm going to get into a little bit more procedurally because it is important in this case. In the end, there was a plea, but there was actually 2 pleas. The first trial court judge accepted a plea from Mr. Bland. There was, prior to the plea, there was discussions in chambers with the judge, and the record reflects that all parties were there, the state, the defense counsel, and the judge. That resulted in the judge offering an aggregate 9-year sentence. This was placed on the record and also made a part of the plea sheets. The state made it clear that they were not agreeing to the sentence, but that the court was offering the sentence. Subsequent to that, Mr. Bland asked to withdraw his plea. He actually withdrew his request to withdraw the plea, essentially saying, yes, I want to go forward with the plea as it is.
Counsel, in terms of that first motion to withdraw,
Yes.
what was the basis? I tried to find that.
The basis was that there was, I believe there was some question between the defense counsel and my client about his time getting out as far as judicial release, and there was some discussion on the record that in defense counsel, I think the record reflects that he mistakenly thought that he advised Mr. Bland improperly, but when he found out that it was, when they cleared up their communication issue, that's when they said, we're okay with going forward with the motion to, so they withdrew their motion to withdraw, and they said they're okay with going forward with the plea. The state then, before sentencing, when it got time for the sentencing, asked the first trial court judge to recuse himself. He held a hearing and addressed several issues. One was whether he was going to recuse himself. The other was sort of some discomfort with agreeing with the 9 years that he had previously agreed to. And the last was whether, in light of the Kubison case, which I was the attorney on, but is now overturned by the White case, but it was before, I believe it was before the White case had come down, and whether in light of the Kubison case, whether the plea was valid. The first trial court judge did recuse himself. It went to a second trial court judge. At this point, the first plea was still there. It wasn't withdrawn, and so the second trial court judge held a hearing and sua sponte invalidated that first plea.
Okay, I have a question about that. And frankly, both sides said sua sponte. Weren't there motions before, outstanding motions about the plea, or were there not any anymore at that point? Did either side have something before that judge questioning the plea?
You know, I don't, okay, so my client had withdrawn his motion to withdraw the plea. So at that point, he said, go forward on the first plea. And I believe the only thing the state had at that point was before the first trial court judge saying, please recuse yourself. So I don't know that there really was a motion. Certainly my client at that point wished to go forward with the original plea and the original 9-year agreement.
How's that an agreement? On the one hand, and on the other hand, does there have to be an agreement if the judge is going to sentence?
Is it an agreement?
Well, you said agreement, but it was an agreement between your client and the state originally, correct?
It was not. It was an agreement between the trial court judge, first trial court judge, but with the understanding that all parties were present. Certainly at that point, the state objected, and there was still an agreement. It wasn't as if there was new information or that the state didn't have an opportunity to be heard. It was, all parties in the record reflects that all parties were, in fact, the defense counsel says that something to the effect of, that all of the parties were present in the chambers, and it's transcript page 20, that all the details of the facts of the case were spoken about at that time. So eventually, the second trial court judge sentenced my client to 15 years, so 6 years additional to the first 9-year agreement.
Counsel, let me ask you, I can't remember the timeline. Did your client move to withdraw his motion to withdraw guilty plea prior to the motion for recusal being filed?
I believe so, yes. It was shortly after he asked to withdraw his plea that he then withdrew his withdrawal, and then the state, I believe in their sentencing memorandum, had asked the judge to recuse himself. And I want to say that was filed right before the sentencing. So I believe that the timeline was my client's motion to withdraw his withdrawal and then the recusal. The 3 assignments of error: one is that the judicial recusal was an abuse of discretion. I realize that this court has previously held that they are not able to address, that the Supreme Court is the only one with jurisdiction to address the recusal. But what I'm asking you to consider is whether that recusal's effect on my client's subsequent plea, the second plea at that point, because the recusal had an effect on the knowing, intelligent, and voluntary plea of the second plea.
Well, did the second trial court judge make any representations about sentencing?
So and I'm going to say transcript page 63, he says, I am not going to participate in specifically references the prior discussions with the trial court judge and the parties, and said that he's not even going to participate in any plea discussions and will not accept a plea unless it's agreed upon by all parties, including law enforcement and the victim. So, for an agreed sentence.
So would your client talking to the second judge, how would your client have had any kind of expectation to get I can't remember, was it 6 or 9 years? 9 years.
Well, at that point, again, he wasn't asking for the plea to be withdrawn. He was asking to go forward on the original agreement. It certainly foreclosed his opportunity for plea discussions in the second plea after the plea was invalidated, is what the trial court had used.
But if a plea is, if you look at case law, they say, plea is based in contract law. How did you have a contract if the state was never in agreement?
Well, I think that's somewhat common for the contract was between the judge and my client, certainly with the information from the state and their objection. So I don't know that the state would have been their necessary party as far as discussions are concerned in information gathering, but ultimately, even if the contract was between the state and my client, the judge has the ultimate decision. So the judge making that is probably a stronger contract than between the state, because the judge has the ultimate discretion. And for the judge to say 9 years, that's a fairly solid contract at that point, especially after hearing the facts of all the cases. And again, the recusal had a negative effect not only on the knowing, intelligent, and voluntary plea, but also my client's right to participate in those subsequent discussions. The trial court judge, second trial court judge said, I'm not even going to entertain an agreed sentence, but for an agreement by all parties, law enforcement, victim, who really aren't typically, maybe victim, but part of the agreement. Certainly,
But
there's
they're certainly part of sentencing considerations.
certainly part of sentencing, and again, I think that's where their voice, it can be heard, but whether they, can participate in that contractual part is questionable.
Right about your 5 minutes.
Okay, let me get to the second assignment of error is again the knowing, intelligent, and voluntarily made of the second plea because of the participation in the plea agreement. So the first judge again had entered himself into the plea discussions, and the second judge actually acknowledged that agreement on the transcript and said, I know that you had an agreement with the first trial court judge, but essentially after withdrawing that plea, did not go along with that 9 years. And my client would ask that 9 years is made to be enforced, as it was, again, all parties were present, and it was an agreement. There was no additional information.
Counsel, we have said, based on Supreme Court holdings, that trial judge should not be involved in plea negotiations.
Right. And again, I think that goes to the knowing, intelligent, and voluntary plea. From my client's perspective, that participation was sort of a enticement for that plea, and then subsequently that was not followed through upon. So it can't be knowingly, intelligently, and voluntarily made because of those discussions with the trial court judge, and this was above and beyond what a normal, yes, I'll follow what the state recommends, or this is the range I'm thinking. This was a definite 9 years, and that's clear on the record. So again, I agree that the trial court judge should, that effect had an effect on the subsequent voluntariness of the second plea because of that sort of bad taste in his mouth. And again, the last is an abuse of discretion on the sua sponte vacating of the plea, because the Kubasin case was part of the decision in sua sponte. Removing that plea, invalidating that plea was based on the Kubasin decision, which is no longer the law. It's now the White case. So I'd reserve the rest of my time.
Okay.
Good morning, judges. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. With regard to the first assignment of error, the voluntary disqualification by the trial court judge simply is not reviewable. That's this court's prior case law holdings, and there's no reason to set forth to believe that this court should depart from the holding. The state cites the Haywood case from just a couple years ago in 2017. Judge Carr, to answer your question, the motion to withdraw was filed, the withdrawal of the plea was filed December 6th. The state filed a recusal motion, I guess, on January 18th, and it was January 26th that the motion to withdraw was filed, so they were staggered, actually.
What was the basis of the state asking the trial court judge to recuse?
I believe there were three bases, Your Honor. One was, the first was, it was an argument about separation of powers. The second was the involvement in plea discussions. And there was a third off the top of my head, reviewing this a few days ago, that
Is that a fancy way of saying they didn't like the sentence he was going to give?
yeah, quite. I mean, ultimately, Judge, the state, and let's be clear, you go back and look at those plea documents, nowhere on there does it say the state agrees to 9 years. The record is perfectly clear that the state never agreed to 9 years and was vigorously opposed to the 9-year sentence. And to but to paint this as the judge being involved in plea negotiations, I don't think the judge was involved in plea negotiations. This is better portrayed as the judge being involved in sentencing negotiations. This is the sentence I'll give you. It was basically presumed, I think, that Mr. Bland was going to plead as charged in each of those 5 cases. There was not going to be any plea bargain offered. So the next best thing for the judge to, I suppose, maybe avoid elongated prosecution proceedings or potentially multiple trials would be to offer some kind of sentence. And I just think that highlights the problem with the court becoming involved in sentencing discussions without the state being involved in sentencing discussions. And to say that there were some kind of discussions in chambers, fine. But the next step is that the state actually has to become involved in trying to establish that recommended number. And if the state's not, frankly, the court probably shouldn't be, because this is the risk that you run as a trial court judge in doing that, and that's that, you start hearing things as the proceedings maybe go along. You start hearing that victims are going to come in. You start hearing that law enforcement's going to come into a sentencing hearing and say something, and you realize that 9-year number just probably isn't appropriate as an aggregate number. Again, an aggregate number too to remember.
And ultimately, was there ever a pre-sentence investigation in this case? I don't recall.
I don't recall either, Judge. The recusal, Mr. Bland said, had a negative effect on the aggregate sentencing. But Judge, failing to recuse would have had a negative effect that permeated the entire proceedings. It was clear that the trial court judge was backtracking on that 9-year number, and it wasn't in favor of Mr. Bland, because frankly, it couldn't have gone much less than 9 years. He was looking at a minimum 4+1 or 3+1 on firearm specs, high felony 1, even if run concurrently between the 5 cases. He was looking at a minimum 7 years. So that 9-year number was not going to get any better for him. And had the judge not recused himself, we would have found ourselves in a situation in which Mr. Bland is asserting that the trial court judge was biased and that there was nowhere else for him to go except as far as the sentencing goes. But again, the abuse of discretion standard isn't even relevant. The trial court judge felt that his impartiality would be questioned, and therefore he recused himself. The case law is clear that it's just not a decision that this court reviews. Whether the guilty pleas made on November 7, 2017, before that second trial court judge, the first trial court judge, was knowing, voluntary, and intelligent, again, is not reviewable. Those pleas don't exist right now. The only pleas that exist were made in June of 20. The pleas of guilty were made, they were actually pleas of no contest, and Mr. Bland was found guilty in June of 2018. The state's puzzled at how this court could review whether pleas that were made in November of 17 and ultimately vacated by the trial court are reviewable.
Well, that also goes to our third assignment of error, that the trial court abuses discretion and vacating the plea.
And Judge, to answer that question, the second trial court judge had no choice but to vacate the pleas of guilty from November 7th of 2017. The first trial court judge did not advise Mr. Bland that by pleading guilty he was surrendering his right against self-incrimination. That's a Criminal Rule 11C2C advisement. It's a constitutional advisement. It's a constitutional right that Mr. Bland would have been waiving. It requires strict compliance orally on the record. The first trial court judge had to advise Mr. Bland before accepting that guilty plea in the felony, of these felony charges. And if he's not advised, it's unenforceable. That's what the case law says. And that's long-standing, well-established case law. It's not knowing, voluntary, and intelligent, the pleas, if Mr. Bland weren't advised of that particular constitutional right and the fact that he was waiving it on the record. Again, it's an issue that would have been grounds to withdraw the plea. It would have been automatic reversible error. It would have been irresponsible for the second trial court judge not to vacate that, the pleas from November of 2017. Kubison is absolutely inapplicable. I didn't exactly write this in my brief. I went at it a little different route, but it's not even applicable. Kubison held that you could look at the documents, that the written plea agreement could enter the guilty pleas. It did not say, however, that the trial court didn't have to advise defendants verbally, orally, on the record of the constitutional rights they were waiving as part of the plea colloquy under Criminal Rule 11. That's not what Kubison said. So Kubison actually, even presuming, I think rightly, that it was controlling at the time, even though it has been since overturned, it doesn't even apply.
Again, except that we see in the transcript, and obviously it's overruled at this point, but except that we see in the transcript that he didn't enter a plea on the record.
But he did plead guilty to, in all 5 cases on the record, orally.
Orally, that's fine.
Orally. Mr. Bland did. So frankly, Kubison isn't even applicable in the way that Mr. Bland's offering to the court. The trial court had the authority to vacate these pleas sua sponte. And again, the case law is clear. The date cites 2 cases, Rondon from 2013 and Lovelace from 1997, this court's decisions to assert that Mr. Bland's contention otherwise, that the court could not sua sponte vacate these pleas. The integrity, as I said, the integrity of the plea process was undermined from the very beginning, and the second judge did tell Mr. Bland, I have no intention of imposing that 9 years. Now, if the parties come in and tell me that they're then in agreement and recommending the 9 years, then potentially, I think you could read the record to say, well, then I might impose 9 years. But unless it was jointly recommended by the parties, the trial court judge was saying, I'm not bound by that agreement, and he wasn't bound by that agreement. This is a separate trial court judge. This was not law of the case.
I have a question.
Sure.
If the first judge stayed on the case
Yes.
and the matter proceeded to sentencing,
Yes.
with or without a PSI,
Yes.
and the first judge still stuck with the 9 years, would the state have had any recourse? Appellate-wise.
Appellate-wise, I don't know. I mean, obviously, under 295308, the state has a right to appeal a sentence.
Let me switch that.
I-
If the first, same facts, let's say the plea's good, there's no constitutional right issue, first judge doesn't recuse, state puts on its sentencing, defense does, and first court says, no, this should be 11 years, 12 years, 16 years, whatever, does the defense have any recourse?
The recourse would be a motion to withdraw the plea, I think.
That's what I'm thinking too, but I just wanted
Would be to
to
withdraw the plea, yeah. I mean, at that point, I think, yes, that Mr. Bland would have gone into and made the plea believing that 9 years would be the aggregate sentence. And if 9 years was not imposed as the aggregate sentence, then maybe he has recourse, I think, to withdraw the plea, you know, I guess under a theory that, well, he could do better if he somehow beats 1 or 2 of the cases at trial. That maybe I couldn't even achieve 9 years, or the state couldn't even achieve 9 years or something, I guess. But that, you know, I don't know that the state would have any recourse. I have to think a little more about that, but I think Mr. Bland would to withdraw the plea. If you have no further questions, the judge, the state asked that the sentence be affirmed. Thank you.
We have just under 3 minutes.
I wanted to address my last assignment of error in the right against self-incrimination. There was a discussion, I wrote down transcript page 30, where the defense counsel says, we don't need to redo this plea, we can advise him of his right to self-incrimination right now to sort of correct that error, and the state agreed to do so. So in order to correct that original plea and go forward on that plea and that agreement.
Well, counsel, let me ask you, let's just say the second judge didn't do the whole withdrawal that your client had pled, and that plea was now in front of that second judge. What are we going to read in the record that would let us see that your client had a good faith belief that he was going to get 9 years?
From the second judge?
That's where ultimately.
Well, again, I think the contract, again, is between, although it's a different judge, it's between, you know, the judiciary and my client to get that 9 years. So I think the expectation would still be 9 years.
But the second judge pretty much told him that's not the case, didn't he?
On the second plea, you mean? Yes. That is true. So, but again, that's, you know, ties into my argument that, you know, when we come before you with my client having pled, we're really limited, you know, we're limited on the arguments here. But I think it's obvious that, you know, the main issue is whether that plea was knowing, intelligently, and voluntarily made. And when you have an individual like Mr. Bland who has had an agreement, and then a subsequent judge comes in and says, I'm not going to follow that agreement, that certainly would have an effect on any subsequent plea. The fact that you can't knowingly enter that plea knowing that you already had an agreement, that's not being followed. And I think for those reasons, he did enter the no contest plea so that he could address these issues. But, and you know, again, that subsequent plea was a no contest for these reasons that maybe he did have the expectation that he wasn't going to get the 9 years, but that he could contest these issues with the first judge and his participation in the plea agreements and how that affected his subsequent plea. Any other questions?
All right, thank you both for your presentation. We'll take the matter under advisement and issue our written decision in due course.